We've got a very interesting panel to talk to us tonight, and I'm going to very quickly hand over to them to let them get started so that gives us enough time at the end for questions and answers. Does that sound all good to you? Fabulous. So first of all, I would like to introduce you to Simon O'Connor, who is a Member of Parliament. He is here on behalf of the Honourable Chris Finlayson, the Attorney-General, and I will hand over to you now. Thank you.
Well, tēnā koutou katoa, ko Simon O'Connor tako ingoa, te meme paramata mo tamaki, me te tia mana o te komiti whiriwhiri ho ora. Good evening and welcome. Simon O'Connor is my name. I am clearly not the Honourable Chris Finlayson. He sends his apologies, but can I just say at the start, Kamatua, thank you for your words. Ngāti Whātua look over me in my electorate, and so wonderful to have you here tonight. The Minister has provided me some opening remarks as context, particularly for his absence tonight, has asked me to read those to you, and then he has what was going to be his speech, and I will read that to you. So strange enough, when I start speaking about I'm speaking about Chris Finlayson, but it's a pleasure to be here and part of this evening. The Attorney-General has asked me to pass on his apologies for not being here this evening. He has asked me to deliver his speech and the following message on his behalf. I am sorry I am unable to be with you in person to take part in this lecture series. I have been in New Plymouth today, initialing a deed of settlement with Taranaki iwi, the 7th of 8 settlements I expect to complete with the iwi of Taranaki. The Taranaki claims are some of the most significant and grave against the Crown. They include war, the use of a scorched earth policy, confiscation of land, broken promises, and imprisonment without trial. It has taken a long time to reach this point. The first Waitangi Tribunal claim from Taranaki iwi was brought by the Taranaki Māori Trust Board in 1987. The tribunal issued its landmark report in 1996. 14 years later, the Crown recognised the mandate of the Taranaki iwi Trust and terms of negotiation were signed. Then, in December 2012, the Taranaki iwi Trust and I agreed on the broad outline of the settlement. Today's initialing signifies the completion of the negotiations. And that's the opening remarks from the Minister, and now for his speech. At this point, I'm sure you're all very well aware that this year marks the 800th anniversary of the sealing of Magna Carta. Largely thanks to the work of the Magna Carta 800 Committee for New Zealand, there have been a number of commemorative events and activities across New Zealand, just as there have been in other countries such as Australia and the United Kingdom. In my capacity as Attorney-General, I've held an essay competition and asked students to write about the significance of Magna Carta in New Zealand today. We received some high-quality submissions, and a student of this university, Max Ashmore, won the University Student category. I also hosted a reception at Parliament last month to mark the occasion. At that event, I started my remarks by quoting Lord Sumption. "It is impossible to say anything new about Magna Carta unless you say something mad. In fact, even if you say something mad, the likelihood is that it will have already been said before, probably quite recently." He is right. Looking at the document in its original context alone makes it difficult to see how it still forms one of the cornerstones of New Zealand's constitution in the 21st century, especially because much of the original text of Magna Carta dealt with grievances specific to that time. There are parallels here with another cornerstone of our constitution, which also happens to be marking a significant anniversary this year. That is, of course, the Treaty of Waitangi, which turned 175 in February. In her address at the swearing-in of Justice Davidson to the High Court last month, the Chief Justice reflected on the anniversaries of these two documents and their importance to our Constitution. The swearing-in of a High Court judge is a significant but under-publicised event, so I want to share with you some of what the Chief Justice said. To quote, "Both Magna Carta and the treaty arose in dramatic circumstances, which certainly fixed them in the national consciousness. Both have their detractors. They are said to be misunderstood or misused through bad history or romantic thinking. It is true that in 1215 and in 1840, many of the things now claimed for these documents lay in the future and were uncertain. But the big ideas they represent and their persistence in popular estimation speak to enduring values which transcend the politics and self-interest of the moment in which they came into being. Only one article of the Great Charter of Liberties remains in force in New Zealand, although that is only because most of the others have been developed in other measures. It is identified in the Imperial Laws Application Act as one of the enactments recognised by Parliament to be constitutional. The Treaty of Waitangi, sometimes referred to as the Māori Magna Carta, is not yet formally acknowledged to be constitutional, but that may be only a matter of time. For present purposes, what is of significance is that both charters were invoked in the courts from their beginnings. Magna Carta has been regularly cited since the 13th century in all jurisdictions which have inherited it, and as the treaty has been in New Zealand cases since 1840. 1840 marked the foundation of the New Zealand we know today. The meaning of the treaty signed that year has been the subject of legal, historical and political debate ever since. While the Treaty of Waitangi does not form part of the statute books, at a bare minimum, it was a guarantee the Crown would treat Māori with respect and honour and would deal in good faith. It does not seem too much to have asked back then, and it does not seem too much to ask now. Indeed, seeking to remedy the Crown's numerous breaches of its own treaty since 1840 forms the basis of my role as Minister for Treaty of Waitangi negotiations. One of the greatest privileges in public office has been to work towards remedying the Crown's actions towards Ngāi Tūhoi. Throughout the 20th century, the story has been one of Tūhoi being misled, ignored, and not consulted on decisions affecting their homeland. Even as late as 1954, just for example, the Crown established Te Urewera National Park, which included most of Ngāi Tūhoi's traditional lands. The Crown did not consult Tūhoi about this and did not recognise Tūhoi as having any special interest in Te Urewera or its management. Tūhoi has always tried to approach resolution of its dispute with the Crown in a principled and determined manner. But up in Te Urewera, the messages were passed down from generation to generation about the unfairness of it all. I will never forget the elderly gentleman who said to me at Ruatoki in relation to the 2007 raids, "I said to my grandchildren, it happened to my grandparents, and now it is happening to you." The Tūhoi settlement legislation passed by Parliament in 2013 and has provided the foundation for a new relationship between the Crown and Ngāi Tūhoi, a relationship in which I hope we will walk and work together for our mutual honour, dignity, advantage and progress. Through my work as Minister for Treaty of Waitangi negotiations, I have great appreciation for the rule of law component in treaty settlements. The Crown, like any other party, has an obligation to adhere to its own undertakings. This is where we can draw parallels to a vital legacy of Magna Carta. The Great Charter has become a powerful symbol of the rule of law. It may not have been the original source of the principle, as Lord Sumption points out in his address, but today it certainly embodies the idea that everyone, including the lawmakers, should be held accountable to the same law. Like Magna Carta, the treaty has come to represent so much more than the mere wording of its original articles. The treaty is so woven through the fabric of modern New Zealand that it would be impossible to unravel the threads, nor would we want to. Like Magna Carta, the treaty was a document of its time, but remains a document of our times. Thank you very much.
Thank you very much, Simon. That was amazing. Simon is also on our Magna Carta committee, so I'd also like to acknowledge the incredible hard work that he's done on that committee. And there's a few other committee members in the room tonight. It's lovely to see you all. So thank you, Simon.